Welcome back to the deep dive. Today, we are undertaking a really critical deep dive into this sprawling legal and financial crisis that's unfolding in Los Angeles County. It's a situation where a massive effort to deliver justice to survivors of, horrific abuse is now being seriously threatened by allegations of systematic, large-scale fraud. The numbers are just staggering.
Yeah.
We're talking about one of the largest settlements in U.S. history for childhood sexual abuse claims. First, L.A. County approved a settlement of over $4 billion for about 11,000 claimants. And then just recently, they added another $828 million for 414 more plaintiffs. So that money, nearly $5 billion total, is supposed to go to genuine survivors of abuse, some of it going back to, 1959?
All the way back to 1959. But here's the conflict. The thing that's thrown this whole process into chaos, this hard-won victory for real victims, is now, well, it's profoundly overshadowed by these explosive allegations that some of the claims were just completely fabricated.
And that some law firms were actually paying people to file these lawsuits.
Right, a practice known as capping.
So what's fascinating here, and what even made this possible, was a specific piece of legislation, right? This created the whole opportunity.
It did. These massive settlements, they stem directly from California's Assembly Bill 218, AB 218.
AB 218 is the engine.
It is the absolute core. AB 218 temporarily lifted the statute of limitations for historical childhood sexual abuse allegations, specifically against big institutions like the county probation and children and family services departments.
The clock had run out for decades on these cases.
For most of them, yes. So AB 218 basically paused that clock, and it allowed thousands of survivors who had, long lost hope of ever getting justice to finally come forward.
Wow.
Without that bill, none of this litigation would even exist.
So the legislation did its job. It opened the floodgates, which was the whole point. But it also, maybe inadvertently, created this massive, very lucrative target.
And that's the tension we're digging into. And let's be really clear, the scale of the abuse itself is heartbreakingly real. Attorney Gregory Yates, he represented Akeelia Jefferson. She was the first survivor to step forward in this wave.
Right.
And he said her courage is what opened the floodgates, leading to the discovery of an explosion of abuse that the county had allegedly, covered up for decades.
He talked about some very specific dark structures within the system, didn't he?
He did, yes. Yates described what he called a cabal of probation officers at these county camps who would just lie in wait for each new group of vulnerable children.
That's horrifying.
He said the probation officer with the most seniority would get, and this is a quote, the pick of the crop. That's the level of institutional failure we're talking about.
That context is it's essential, because you have to understand the moral weight behind these payments. But the financial cost is now putting a huge squeeze on L.A. County taxpayers.
It certainly is. That $4 billion settlement alone has already led to very concrete financial consequences.
We're talking budget cuts.
Mandatory 3% budget cuts across many county departments this fiscal year, and reductions in some public services because of it. It's a massive hit. It impacts everything.
So with that financial pressure building and the fraud allegations starting to bubble up, the county initially tried to walk a very fine line. The Board of Supervisors Chair, Catherine Barger, she acknowledged that the system created by AB 218 is, quote, inherently vulnerable to fraud.
Right, but she insisted the county had strong protections in place to make sure the funds go only to the true victims.
But that's where the legitimate victims' attorneys really pushed back. Hard.
Oh, absolutely. Attorneys like Courtney Tom and John Manley have been extremely critical of the county's handling of this. Tom, who's a former prosecutor, she was just scathing. She called the alleged misconduct plain fraud and corruption on the highest level.
And her firm, they were raising red flags about this for months, weren't they? Why wasn't the county listening or acting sooner?
That is the big question. It raises serious concerns about negligence. Tom claimed her firm warned the county about fraud issues in court documents over and over again, and yet she alleged the county did no due diligence to investigate. Nothing.
And then the story breaks.
Then the scandal finally breaks in the press, and she said the county's first response was just to attack the victims by casting doubt on the whole process instead of going after the actual fraudsters.
So the criticism isn't just that the fraud happened, but that the county allegedly ignored the warning signs and then completely mishandled the fallout.
Exactly. It just compounded the tragedy.
Okay, let's pivot now to the mechanics of the alleged fabrication, because this is where it gets really, really cynical. The LA Times investigation focused heavily on one firm in particular, Downtown LA Law Group, or DTLA.
And they had a huge number of cases, over 2,700 cases in that $4 billion settlement.
And the report found that some plaintiffs were allegedly paid by recruiters for DTLA to sue the county, and in at least 2 cases were coached to completely make up their claims.
This practice is what we call capping, or sometimes people call it running. The Consumer Attorneys of California, the CAOC, they are now demanding an urgent state bar probe into DTLA. They allege the firm used recruiters who specifically targeted people near a county benefits office,
Offering them cash.
offering up to $200 in cash just to show up, and even giving them rides to the firm's office.
So this isn't just aggressive advertising. We're talking about direct cash payments to people to bring clients to a specific law firm. That is just explicitly illegal in California, correct?
Absolutely correct. This is not a gray area. It's not a loophole. Paying intermediaries or cappers to drive claimants to a particular attorney is precisely what California Law Business and Professions Code Section 6152- prohibits.
And the details of how this allegedly worked are
Yeah.
just bizarre.
Yeah.
Unforgettable. Take the anecdote about Austin Beagle and Nevada Barker.
Right, this is wild.
They had just moved from Texas and claimed they were offered $100 each just to be extras outside a county social services office. They literally thought they were going to be on a movie set.
But instead, they ended up at the law firm's office. And there, they allege they were told to memorize a card, basically a short script, to claim they were sexually abused or harassed by guards at Los Padrinos Juvenile Hall around 2005.
And Beagle remembered being coached with the phrase, "The worse it was, the better."
Just think about that for a second. The worse it was, the better. That is a calculated instruction aimed at maximizing a settlement value based on, well, purely fictional trauma. After this intake meeting, they were allegedly paid $100 each by a man named Kevin, who then offered them another $100 for every single person they could refer.
And Barker said she couldn't give details during her interview because, quote, it was all made up stuff.
Beagle even said he thought the law firm staff might have been acting like they were pretending not to know the whole thing was fake.
Wow, that just implies such a profound systemic level of deception.
It is deeply disturbing. But we have to pause and think about the crushing impact this has on the real survivors. Victims have expressed just immense outrage and disgust. They're terrified that these fraud allegations will completely derail the entire settlement, or worse, just cast permanent doubt on their own truthful experiences.
I mean, can you imagine enduring that kind of abuse? Finally seeing a path to justice through this law, only to have the credibility of your life-altering trauma undermined because someone was paid $100 to lie about it.
That is the core tragedy here. Trinidad Pena, who sued over an alleged rape at McLaren Children's Center, she said it was sickening for someone to lie about abuse when she carries those scars every single day. And another survivor, Cornelius Thompson, voiced the crucial question that must be haunting thousands of plaintiffs right now. Will he still be believed?
It's a vicious cycle.
Yeah.
So what is the system doing now to contain this? The county had to act after this reporting broke.
They did. The Board of Supervisors immediately directed its attorneys to investigate the allegations against everyone included in that initial $4 billion settlement. The county counsel, Don R. Harrison, stated clearly that this conduct undermines the entire justice system and deprives legitimate claimants of just compensation.
And they've introduced a much stricter vetting process now. Was that not standard procedure before?
That's the key question, isn't it? The new process requires every plaintiff to provide a detailed, multi-page written factual summary under penalty of perjury.
So they have to swear to it now.
Exactly. Outlining the alleged misconduct and the harm. And claims found to be fraudulent will get the plaintiff removed from the settlement. Zero compensation. The fact that they have to do this now suggests the initial due diligence was critically flawed.
And beyond the county, the broader legal community is now under intense pressure to police itself.
Absolutely. The president of the CAOC, Jeffrey Wells, he demanded the state bar immediately investigate downtown LA Law Group. And this is a really critical moment for the state bar.
Because of past failures.
Yes. As another attorney, Nicholas Rowley, pointed out, the profession needs to start policing ourselves. He noted that the state bar is still rebuilding itself after, notoriously ignoring the misconduct of another attorney, Tom Girardi, for decades.
So the stakes are incredibly high for them. Any inaction would send a really dangerous message.
A very dangerous message. And there's also a legislative push.
Right, for Governor Newsom to sign a new bill.
Senate Bill 37, yeah. This bill would allow consumers themselves to sue for unlawful attorney solicitations. It's about giving people a direct way to fight back against these illegal recruiting schemes.
And we should know DTLA isn't the only high-volume firm facing this kind of scrutiny. Slater Shulman, they represent 3,500 clients in the LA case. They also ran into issues in the Boy Scouts of America bankruptcy.
They did. The settlement trust there identified procedural and factual problems in some of their claims, which forced the firm to hire a third-party neutral just to review them. It really solidifies this idea that when legislation like AB 218 opens a huge lucrative window, it attracts both genuine victims seeking justice and, well, unscrupulous actors looking to exploit the sheer volume for a quick profit.
That distinction, industrialized litigation versus genuine justice, is the perfect bridge here. Let's transition to a completely separate case involving the same law firm, DTLA, because it gives us a clearer look at an alleged pattern of misconduct in a totally different area: rideshare injury claims.
And this is a major development. We are talking about a federal Racketeering, Influenced, and Corrupt Organizations Act lawsuit, a RICO lawsuit,
A RICO suit.
filed by Uber Technologies, Inc. in July of 2025. They're suing DTLA, another law firm, and specific medical providers.
Wait, Uber is suing under ARCO. That's usually reserved for, like, organized crime. What is Uber alleging here?
They're alleging a highly coordinated criminal enterprise. Uber claims the defendants were directing injured passengers to pre-selected medical providers. And these providers allegedly performed unnecessary treatments and submitted bills that were wildly inflated. In one case, Uber says the bill was 10 times the market norm.
So the goal wasn't patient care. It was just maximizing the costs.
Precisely. The goal was to exploit California's state-mandated $1 million rideshare insurance policy limit. Uber claims the entire scheme was designed to generate high, often inflated litigation costs to induce significantly larger settlement payments, right up to that $1 million limit.
So they're seeking to get money back.
They're seeking to recover millions in legal defense costs and settlements they feel they were forced to pay. And beyond that, Uber is actively supporting legislation to lower those insurance limits, pointing to similar successes in places like New York City.
And what was DTLA's defense?
Yeah.
They strongly denied this, right?
They strongly denied the baseless allegations, calling the lawsuit an attempt by Uber to suppress legitimate injury claims. Their key defense point was that Uber, this multi-billion-dollar company, never actually took any of the disputed cases to trial.
Their argument being, if you thought they were fake, you should have fought them in court.
Exactly. If you truly believed the claims were meritless or fraudulent, you had every chance to prove it.
That brings us right back to the central paradox of this entire deep dive. When you connect these two areas, the child abuse settlements and the rideshare torts, you see an alleged pattern emerging. You have this massive legislative effort, AB 218, designed for justice for true survivors, and it's now potentially imperiled. Its purpose is stained by these widespread allegations of sophisticated commercial fraud.
It really shows the two simultaneous pressures on our legal system. On one hand, you have the moral and legal imperative to compensate thousands of abused children. That has to be protected. But on the other hand, you have this urgent need to protect the system and taxpayer funds from being exploited by these profit-driven, industrialized schemes.
And when you circle back to the specifics, that couple, Beagle and Barker, coached to play the part, thinking the staff might be acting. It just suggests that for those allegedly running the scheme, the trauma was just a script, easily replicable and very profitable. So given the severe financial consequences already hitting LA County and this new focus on the justice system's vulnerability to fraud, here's a provocative thought for you to think about. What impact will these confirmed fraud cases have on any future legislative attempts to lift statutes of limitations for other categories of historic abuse claims? Will the risk of fraud now outweigh the promise of justice?
An excellent and I think necessary question to consider as these legal battles continue to unfold. Thanks for joining us for this deep dive.